Is my slide visible? Are my slides visible? Somebody confirm.
Yes, sir. And also the recording is also started.
Okay, great. A very good morning, everyone. Welcome to the sixth session of this workshop. Over the course of this session, this is not going to be a very big session because this is going to be more on the commercial side of things and a very few insignificant, perhaps, uh, legal questions will be dealt with. So over the course of the next 1 hour, we shall be looking at, as the topic suggests, like multiple strategies that are involved in negotiating a deal, the commercial aspects that have to be looked into it, and then legal considerations. Following which, we shall be looking at how a deal is exactly executed before its closing. So let's get started with today's lecture with understanding what the techniques for negotiating M&A agreements involve. So negotiating mergers and acquisitions agreements is like, how do I put this? Is a complex and strategic process that requires a nuanced understanding of both legal and commercial considerations. The techniques that are employed in these negotiations are shaped by the nature of the transaction, the relative bargaining power of the parties, the structure of the deal, which is like asset versus share purchase or merger versus acquisition. The jurisdiction legal frameworks that govern such agreements, etc. So at the heart of M&A negotiation lies the balancing of risk allocation between the buyer and the seller, where each party seeks to minimize exposure while securing favorable terms. So consequently, seasoned negotiators deploy a blend of technical expertise, market awareness, and tactical communication to achieve optimal outcomes. So the foundational technique, as we have been discussing in the previous classes, is due diligence, which not only informs the valuation but also frames the negotiation strategy. And buyers typically begin negotiations with an extensive due diligence, which will include, obviously, as we've discussed, legal, financial, operational, and tax. And these are in place to uncover, liabilities, assess regulatory compliance, and understand the target assets base. The target's asset base. So the findings from this process usually serve as a leverage or serve as leverage points rather for price adjustments, indemnification demands, or changes in the deal structure. So sellers, however, in contrast, may engage in vendor due diligence beforehand to prepare the disclosure schedules and identify red flags early. That will hence minimize post-negotiation surprises and preserve the deal value. One classic negotiation tactic that is in place is the anchoring and framing. So usually these are used in the early in the process to set the tone. Excuse me. The buyer might make an initial offer that anchors the valuation low, leaving room. I think it will leave room to move upward through concessions, if I am to put it, while still staying within their target range. So the seller, on the other hand, may frame the discussion around strategic synergies, if I am to put it that way, or past performance to justify a premium. That is to say, to very simply put it, I'm sorry for the complicated language that I might have spoken in. You will have, on one hand, you will be as a seller, you will be indicating your performance, your track record to ensure that you are purchased or your shares or your assets are purchased at a certain price. And at the same time, the initial offers that the buyer makes will be something that might possibly be put in a certain number, and will also be accompanied with certain early demands, so that uh, they can later on shoot up the price. They can later on bring in more concessions as may be negotiated from time to time with the buyer, and therefore add to whatever they're getting in kind in addition to whatever amount they're paying. So that is also an economic gain at the end of the day, right? Be it in the form of research and development, if you're undertaking a mere share purchase, or the associated research and development if you're undertaking an asset purchase, which did require the research and development or the technical know-how that came with it. At the same time, probably engulfing certain employment. I mean, em- em- uh, I mean, employment structures within the target company itself or the seller company. So these are things that can be sought for as concessions. So the initial base price is not exactly is to impress investors as well as the seller, not exactly set to a significantly high amount. And of course, your commercial incentives will keep concessions rather will keep coming in kind as well as you negotiate it, which is why we call it anchoring and framing. So both the parties utilize what we call term sheets and letters of intent as pre-agreement frameworks to outline key commercial terms such as perhaps purchase price, payment structure, cash stock earnouts, and exclusivity periods. So these documents help reduce ambiguity. They also help establish intent and also create alignment on major deal terms while deferring more technical negotiations to the definitive agreement stage. So in drafting and negotiating the definitive agreement, that is your share purchase agreement or an asset purchase agreement, parties will often focus on risk allocation mechanisms such as representations and warranties, covenants, closing conditions, indemnities, and escrow or holdback provisions. So sellers seek to limit their exposure through narrow and or qualified representations. Uh, uh, and perhaps time-bound indemnities, if I have to put it that way, which will often be accompanied by caps and baskets. So buyers, on the other hand, will push for broad representations, longer survival periods, and mechanisms like escrow accounts or warranty indemnity insurance to ensure that there is a recourse that is available, or to ensure that it becomes a more subjective clause to play around with, so that if there is any unforeseen disadvantage that is being created beyond the scope of what the specific representation or warranty is, they can claim that it is included within the broader representation or warranty. So it becomes easy that way. So what it ultimately indicates is that negotiators must be adept at understanding how each clause interacts over negotiating one term and maybe traded off for perhaps concessions on the other, especially under what we call a give and take or package deal approach. So understanding market norms and industry specific standards also plays a crucial role, particularly when negotiating with sophisticated counterparties or in regulated sectors. What I'm trying to say is experienced negotiators rely on benchmarking against recent deals to argue for or resist particular terms. Let me give you an example. So there are you might have we've discussed these clauses, right? Material adverse change clauses, non-compete agreements, or even earnout agreements. So they often reflect what is customary in the industry. So if there is any deviation from such norms, it must be justified clearly. So also timing and pacing of the negotiations also form a part of the negotiation strategy. So buyers might deliberately prolong the negotiations to capitalize on the financial distress or market fluctuations, while the sellers might accelerate timelines to prevent deal fatigue or attract competing offers. So techniques such as bluffing, good cop, bad cop, control disclosures, excuse me, Excuse me. Excuse me. So they are sometimes tactically employed through, though overuse may erode the trust and backfire. So the strategic use of walkaway alternatives also therefore will add negotiating strength. Having a viable alternative to the current deal, because it will enable a party to stand firm on critical terms. Now, another sophisticated technique that is employed is called the dual track process, where which is often employed by sellers, where a company simultaneously explores both a sale as well as an IPO, like what to understand what is more economically feasible for it. So this not only increases competitive tension among the bidders, but it also strengthens the seller's negotiating position by creating optionally and timely pressure. So, I mean, meanwhile, if you have like a cross-border M&A transaction, negotiators must also navigate cultural sensitivities or perhaps divergent legal systems and regulatory approval timelines, which will necessitate flexible approaches and multi-jurisdictional expertise, so as to put it. Sorry, just give me 1 minute. My screen is frozen. I'm not able to move to the next slide. I'm really sorry. Just give me 1 minute. Sorry, is this slide visible now? Role of legal advisors in negotiations? Okay. Thanks, Kriti. Thanks, Akanksha. Yeah. Thanks, everyone. Okay. So let's now come to the role of legal advisors, right? So legal advisors, typically law firms specializing in M&A and corporate transactions, or independent consultants, independent corporate like consultants, will serve a broad spectrum of functions through the negotiation process. So at the preliminary stage, they assist in the structuring of the deal. That is, whether it is to be an asset purchase or whether it is to be a share purchase, or a merger or a slum sale or a hybrid. So each structure carries different tax implications, regulatory approvals, and commercial consequences. So legal advisors draft and review term sheets and non-disclosure agreements, ensuring that confidentiality is preserved and that initial commercial understandings are properly captured. So as that negotiation moves forward, the legal advisors become central to drafting and negotiating the definitive transaction documents, such as the share purchase agreement, the asset purchase agreement, merger agreements, shareholder agreements, and even ancillary agreements like transition services agreements, non-compete clauses, employment contracts, etc. So the lawyer's role here is not limited to drafting, but to actively shape negotiations by calibrating representations and warranties, indemnities, limitation of liabilities, and dispute resolution mechanisms, among others. So they ensure that the documentation reflects the commercial intent while protecting their client's legal position, especially in terms of risk allocation and enforceability. So in transactions involving regulatory oversight, such as in the case of listed entities or cross-border acquisitions, legal advisors also handle regulatory compliance and approval processes, which include filings with the Competition Commission of India, the Reserve Bank of India, the Securities Exchange Board of India, or sectoral regulators like IRDAI or TRAI. Those are the Insurance Regulatory and Development Authority of India and the Telecom Regulatory Authority of India. So they conduct legal due diligence to identify contractual, statutory, or litigation-related risks and liabilities that may require pricing adjustments or indemnification. What is then the role of financial consultants? So financial consultants, which include investment banks, valuation experts, and financial advisory firms, play a role in actually a very important, like the most important role in conducting valuation, pricing, and deal structuring for the transaction. This is where Ajay had asked the question in the previous class about valuation methods. This is where I'll be discussing that book building methods and the other methods. So pay close attention. So one of the primary responsibilities is of these financial consultants is to determine the value of the target entity, ensuring using a range of methodologies, and each is suited to a different transaction. So the most commonly used method in M&A or IPO bound acquisitions is what we call the book building method. So book building is basically a price discovery mechanism that is used to determine the optimal price at which securities should be issued or shared. So under this method, an investment bank, which is acting as a book runner, invites bids from potential investors with a specified price band. So these bids indicate the quantity of shares the investors are willing to buy and at what price. And the demand at various price points is compiled into a book, which helps determine the cutoff price. So the price at which the issue will be offered to the public is what we call the cutoff price. So in the M&A context, particularly when acquiring public companies or selling a stake, via competitive bidding, the book building methods helps the seller or acquirer discover a market validated valuation, especially in auction style or what we call public solicitation. So it is crucial in cases where pricing must be transparent and defensible before regulators or minority shareholders. Is the book building method clear to everyone? Before I move on into the other methods, I really want to understand if there's a need for me to repeat it. I can explain it any number of times. Let me know if anybody has any doubt with regard to the book building method. Okay, I take that as none. Okay, let's come to the next method then, which is discounted cash flow analysis or DCF analysis. So this is a forward-looking method that estimates the present value of future cash flows, discounted at an appropriate risk-adjusted rate. So it is often used when the target has predictable earnings or cash flows. So if there is a future share price that can be determined, so usually in India, forward contracts are illegal, but this price determination may be considered valid because, you're not technically entering into an agreement, but you're giving a predetermined price basis, an intelligible understanding. You're paying the price at present, you're not agreeing to pay it at a future point in time, right? Irrespective of whatever's there in place. So while this may not be treated akin to a put and call option, which are legal, these will, and it's not like, obviously it's not giving you an option. It's just because it's giving you an option to probably fall out in a contractual arrangement where this is utilized for the purpose of valuation. It does not become akin to a put and call option. It will remain just a mere methodology of calculation by employing what exactly could be the value of certain shares or assets at a futuristic point in time. And of course, if there is a discounted rate to the same, that can possibly be applied because of the risk that comes because of market volatility, which can see a decrease in price and many a times, of course, increase in price as well. That price is predetermined, and then of course the valuation is estimated. So it is often used when the target has what we call predictable earnings or cash flows. So the next method that is there in place is the comparable companies analysis, or what we call trading comps. So this involves comparing the valuation multiples like EV, EBITDA, or private equity of peer companies to determine a fair valuation range. Then comes your precedent transactions analysis, which is what we call the deal comps. So this looks at past M&A transactions in the same industry to assess valuation norms and premiums paid. Then comes your asset-based evaluation, which is basically used for asset-heavy companies. And this method is based on the net asset value derived from the company's balance sheet. So in addition to valuations, financial consultants manage what we call financial due diligence, which will examine the target's historical financials, revenue models, debt and capital structure, contingent liabilities, and working capital requirements. So they also advise on the deal financing strategy, which will include debt structuring, bridge loans, mezzanine financing, or equity issuance, depending on the acquirer's capital strategy. So financial consultants are instrumental in preparing what we call information memorandums, which will manage data rooms and coordinate with multiple stakeholders, including lenders, rating agencies, and data regulators. Not only data regulators, actually, market regulators like SEBI, RBI, etc. So in a competitive sale process, they may also run the entire transaction through auction mechanisms, which will evaluate multiple bids and advise the seller on optimal timing and sequencing. The next thing that we shall be dealing with is what we call combined strategic role during negotiations. Now listen to me very carefully. So in negotiation settings, both legal and financial advisors work collaboratively, correct? Like if a buyer proposes an earn-out clause contingent on future performance, the financial consultant assesses its feasibility and forecasts, while the legal advisor drafts the clause to minimize ambiguity and ensure enforceability. So similarly, a valuation gap may be bridged by deferred considerations or escrows, with financial consultants proposing the structure and legal advisors codifying it into the SPA. So another key intersection is during risk allocation, especially in indemnity negotiations. Financial advisors quantify the risk exposure while legal teams negotiate thresholds, caps, baskets, and survival periods. So together they shape a package deal where each negotiated term aligns with the client's financial model and legal protections. So in large or cross-border deals, coordination between legal and financial advisors is even more vital, given the need to harmonize the local laws with the international best practices that are in place, manage exchange rate risks, and navigate the cultural nuances that are involved in deal making. Sorry. Then comes the next topic for today, which is managing risks and dispute resolution mechanisms in M&A. But before that, does anyone have any question with regard to what we've discussed? Because I can understand that these are very new things for all of you. So if you have any questions, you please unmute and ask me. That's my job, right? I'm here to clarify all questions. I know it is not easy to understand these things because many of them are not very legal. But if you have any questions, please ask me. I can repeat as many times as you want me to. Okay. I think everyone's understood everything. So let's then come to the next topic, which is managing risks and dispute resolution in M&A transactions. So managing risks and dispute resolution in M&A transactions is a critical aspect of ensuring the stability, enforceability, and long-term success of the deal. So given the multitude of variables involved, excuse me, which range from valuation disagreements and undisclosed liabilities to regulatory compliance, failures and post-closing performance issues, effective risk management requires forward-looking and a legally robust approach. So we just give me 1 minute, please. Excuse me. Excuse me. So effective risk management will ultimately require a forward-looking and legally robust approach. And equally important is the incorporation of the structured dispute resolution mechanisms that offer clarity, reduce uncertainty, and preserve value in the event of future disagreements. So these two elements, risk mitigation and dispute resolution, are not reactive tools, but they are built proactively into the transaction through legal drafting, due diligence, deal structuring, and negotiation strategy. So what exactly is risk management in M&A transactions? Now, the primary method for managing risk in M&A deals is through comprehensive due diligence, which allows parties to identify legal, financial, tax, operational, and compliance risks associated with the target business. So legal due diligence uncovers issues such as perhaps defective titles, pending litigation, non-compliance with statutory obligations, regulatory lapses, or even contractual breaches. So financial due diligence focuses on issues like misstated earnings, revenue recognition practices, off-balance sheet liabilities, and unsustainable debt levels. So these insights directly influence. Sorry, do I see a hand raised? Okay. But somebody had raised their hand. So, what was I saying? I'm so sorry. Yeah. So these insights directly influence the structuring of the transaction, whether certain liabilities are ring-fenced, indemnified, or reflected in a price adjustment mechanism. So once identified, risks are typically allocated between parties using representations and warranties, as we've discussed, indemnities, conditions precedent, and escrow holdback mechanisms, which we've also discussed. So let's look at how exactly these work. So representations and warranties, I'm sorry, some of this might be repetitive, but it is important for me to give you this background to understand what we're going to discuss in terms of their roles when it comes to risk management. So representations and warranties are contractual statements that are made by the seller about the conditions of the business. And if they are later found to be false, they can trigger claims. So sellers often seek to qualify these statements with materiality thresholds. And I think also knowledge qualifiers and specific disclosures. I think you can note all of these three down for that matter. Then indemnity clauses then allow Actually, let me give me a minute to think this. I think I'm being very complicated here. Okay. I'm sorry. I'll make it very simple for you. I think of using a lot of complicated terms unnecessarily. Okay. So indemnity clauses then allow the buyer to claim compensation for the losses arising from breaches of these statements or other specified risks, which we've already discussed, like things like ongoing litigation, tax disputes, or environmental liabilities. So indemnities are usually time bound and are subject to financial limits, including caps, baskets, and de minimis thresholds. So just to repeat, how exactly your representation and warranties can be qualified. So these can be materiality thresholds, knowledge qualifiers, and specific disclosures. And of course, to just further brief you on what we just discussed, the indemnity clauses will allow the buyer to claim compensation for the losses arising from breach of these clauses, and then allow the buyer to claim compensation for losses arising from breach of these statements, or other specified risks like ongoing litigation, tax disputes, or environmental liabilities. Indemnities, on the other hand, are usually time-bound and are subject to financial limits, and these will include your caps, baskets, and your de minimis thresholds. Any questions before I move on into what understanding escrow arrangements, which I know we've discussed very significantly in the last class, but yeah, I'd just like to repeat it for the purpose of understanding risk management. So let me just take this place a little. Yeah. Does anybody have any questions? Okay. So escrow arrangements are another common risk mitigation tool where a portion of the purchase consideration is held by a neutral third party for a specified period to cover any post-closing claims. So this gives buyer a secured recourse without pursuing lengthy litigation. Now, excuse me, in certain deals, warranty and indemnity insurance is used to shift the risk to an insurer, especially in competitive transactions where the seller prefers a clean exit. Now, this allows the buyer to recover losses without pursuing the seller, while enabling the seller to distribute sale proceeds promptly. Now, additionally, buyers may negotiate adjustments to the purchase price through working capital adjustments, earnouts, or deferred consideration, which help protect against overpaying due to overestimated forecasts or accounting anomalies. Now, for instance, an earned tie-out ties a portion of the price to the future performance of the business, incentivizing the seller to maintain business continuity and aligning business continuity and aligning expectations on evaluation. Hence, the next question that comes is, what exactly are the dispute resolution mechanisms that are in place? What's happening? I'm not able to open the Meet screen. Okay, I got it. The group page. So despite best efforts at risk allocation, disputes can arise, but in fact, to put it very frankly, can and do arise, particularly in complex or cross-border M&A transactions. So disputes may concern alleged breaches of representations and warranties, earn-out disagreements, non-compete violations, or post-closing adjustments. So to address these efficiently, the M&A agreement typically incorporates structured dispute resolution mechanisms that set out the forum, procedure, and applicable law. So the first line of dispute resolution often involves negotiation and consultation, which will require the parties to attempt amicable settlement before resorting to formal procedures. So this is followed by options such as mediation or expert determination. Expert determination is particularly effective for technical disagreements such as valuation adjustments, accounting disputes, or earnout metrics, where a neutral financial or industry expert renders a binding decision on defined parameters. Where disputes cannot be resolved amicably or technically, the parties proceed to either arbitration or litigation, depending on what has been agreed under the dispute resolution clause. Um, so, I mean, why arbitration is pretty prominent, litigation, though less common in private M&A deals, may be used where public companies are involved or where regulatory scrutiny necessitates judicial intervention. Indian courts have become increasingly more efficient in dealing with commercial disputes, rather are becoming more are becoming increasingly efficient, particularly with the establishment of commercial courts and the adoption of timelines under the Commercial Courts Act of 2015. So another layer of dispute prevention is the governing law and jurisdiction clause, which become particularly important in cross-border M&A. So it defines substantive law. It defines the substantive law that governs the contract and the forum where the disputes will be adjudicated. So the choice of law impacts how the contract is interpreted, what remedies are available, and how damages are assessed. As part of the trends in arbitration, let's understand that parties can select the arbitral institution, such as the SIAC, the LCIA, the ICC, and then followed by the seat of the arbitration and the language as well as the number of arbitrators. So well-drafted arbitration clauses reduce procedural ambiguity and prevent jurisdictional wrangling. So in domestic Indian transactions, arbitration under the Arbitration and Conciliation Act of 1996 is widely adopted for similar reasons. Let's then quickly look at what post-closing monitoring and enforcement is before we move on into our case study and the role of risk management, right, in the post-closing monitoring and enforcement. So risk management, let's say, does not end at closing. Effective post-closing integration plans, governance frameworks, and compliance monitoring are essential to minimize the emergence of disputes, and ensure that the transaction objectives are achieved. So buyers may appoint post-closing compliance officers, internal audit teams, or third-party monitors to ensure that the target's operations align with the legal and business expectations of that company. So in shareholder-driven transactions, dispute risks may arise over governance, management control, or board decisions, and hence shareholder agreements often contain deadlock resolution clauses like buy-sell rights, drag-along, tag-along rights, put-call options, which act as internal dispute resolution mechanisms within the entity. So this is about risk management. Are there any questions before we move on into the example? Come on, it's not possible that all of you are well versed with everything as soon as I just said it. Either I am an exceptionally good instructor or you all are like exceptionally smart individuals who are attending this lecture. Surprising that none of you have any questions. Okay. I mean, I'm limited to whatever I can respond to on screen. So let's move on with the case study or the example. So let's take the example of let's take the 2006 example of the Mittal Arcelor hostile takeover. So this is a very high profile example of negotiation tactics. So this is a pre-2013 Companies Act position. So let's not really pay much heed to the law. I am only referring to this example uh, for your understanding of negotiation tactics. So uh, why I took this example is because it illustrates not only the legal and financial dimensions of such deals, but also the use of political leverage, public relations, and counter strategy in what was initially a fiercely contested acquisition. So the deal ultimately resulted in the formation of ArcelorMittal, which is now one of the world's largest steel companies. So the background, let's look at the background, right? Uh, I mean, that's how I think we need to start. And I'm not going to spend a lot of time on the background because I think the negotiation tactics is where we need to spend some time. So in January 2006, Mittal Steel, which is owned by an Indian origin entrepreneur, as you all know, Lakshmi Mittal, launched a hostile takeover bid to acquire Arcelor, which was a European steel giant based in Luxembourg. So at that time, Arcelor was Europe's largest steelmaker and had a politically sensitive profile, given its partial state ownership and European roots. So at that point in time itself, uh, so Mittal had offered a whopping how much was it? Yeah, 18.6 billion euros. I I'm sorry if I've not provided that on the slide, have I? I'm really sorry. I didn't provide the initial price on the slide. It was 18.6 billion euros that was initially offered, which proposed for a share-for-share transaction at a significant premium to Arcelor's trading price. So Arcelor's board rejected the offer outrightly. It called it unsolicited and undervalued, and questioned Mittal's corporate governance, integration capacity, and commitment to European values. So the rejection set the stage for a hostile takeover battle that lasted several months and involved aggressive negotiation tactics on both sides. So what were these tactics? Uh, so Mittal steel tactics, okay, I would like to indicate it in a fourfold manner. Now, first, there was a public pressure and shareholder appeal. So what Mittal Steel did is it took its bid directly to Arcelor's shareholders. It recognized that the board was resistant, and Mittal launched a global media campaign and investor roadshows, emphasizing the synergies of the combined entity and offering a significant premium it also targeted institutional investors and made them question Arcelor's defensive tactics. And Mittal therefore placed pressure on the board to justify their resistance. The second tactic that Mittal Steel employed was incremental concessions. So as the deal progressed and resistance mounted, remember the first part of the lecture where we said a base price is quoted and they keep taking concessions in kind. So that is what exactly Mittal offered outright here, where Mittal enhanced its offer several times, increasing the exchange ratio and adding a cash component. So this tactic is what we call creeping concessions. It was strategically used by Mittal Steel to win over skeptical shareholders without immediately conceding too much value upfront. So you quote a lower base price and you keep providing things in concession. Or if you are quoted a low base price, if you're not performing that well in the market, to ensure that you perform well as a seller, you keep taking things in concession. So the next tactic that Mittal Steel employed is reputation management and public relations. Excuse me. So Mittal Steel countered concerns over corporate governance and social commitment by strengthening its board, adding independent directors, and announcing it would maintain dual headquarters in Europe. It also engaged European media and politicians to improve perceptions about its intentions and operations. The fourth tactic that Mittal Steel employed was what we can call regulatory preparedness, which is where Mittal Steel proactively sought and obtained antitrust and regulatory approvals across multiple jurisdictions, demonstrating deal readiness. So this reduced uncertainty and made the deal more attractive to shareholders who otherwise feared regulatory delays. So then we have to discuss what Arcelor's defense tactics were, right? Which is very important. So the white knight strategy is what they employed first. So in response to the bid, Arcelor sought a white knight merger with Severstal, which is a Russian steelmaker, in a move perceived as an attempt to dilute shareholder power and avoid the Mittal acquisition. So this defensive tactic basically aimed to create a friendlier alternative, but was controversial and widely criticized as a governance breach. The second tactic that they employed is what we call the poison pill tactic. Sorry, Sharmila, do you have a question? I saw you switching off your camera.
No, sir. I'm sorry.
Yeah, okay. So now, while the EU laws limited the scope of US-style poison pills, Arcelor attempted structural defenses through board-led maneuvers. Let me understand how to put this very simply to you. Yeah. So Arcelor attempted structural defenses through board-led maneuvers like share buybacks, strategic reclassifications of assets, which were intended to make the acquisition more difficult and costly for Mittal. So then came the appeal to nationalism and political influence. So Arcelor leveraged political opposition in France. Uh, uh, Luxembourg, I think. Yeah, but the political opposition was where at that point geographically, if I am to recall it correctly, it was in France, Luxembourg, and Spain, which framed yeah, sorry for taking that time. I just thought how to present it to you simply because if I just mention a very if I just mention it very technically, it'll just go. It's not going to serve the purpose. Yeah. So with the political oppositions being in these three countries, so what Arcelor did is they framed Mittal's bid as an attack on the European industrial sovereignty. And politicians then, including the then French president Jacques Chirac, they expressed concern, and this was an appeal to non-economic factors to sway away public opinions or public and shareholder opinion for that matter. The fourth tactic that Arcelor applied was undermining acquirer credibility. So Arcelor's board launched a campaign questioning Mittal Steel's financial practices, family control, and transparency. And the aim was to create reputational doubts and discourage investor support for the offer. What was the resolution and negotiated settlement hence, right? So now, despite Arcelor's staunch resistance, increasing shareholder pressure and criticism of its Severstal deal forced the board to reconsider. Now, as the support for Mittal grew, Arcelor withdrew from the Severstal merger and began direct negotiations with Mittal Steel. So in June 2006, after prolonged resistance and under sustained shareholder and market pressure, Arcelor's board agreed to a negotiated transaction. Mittal improved of its previous offer of 40.40 euros per share, and improved its previous offer to 40.40 euros per share, which took the valuation of the deal to around 26.9 billion euros, which was a significant increase from the original bid, which was 18.6 billion euros. So, though still a hostile bid by initiation, the deal concluded as a friendly merger, with both sides agreeing on corporate governance terms and board composition for the combined entity. So key takeaways on this, on hostile takeover negotiation tactics, is what we shall now be looking at. So the first takeaway is your going hostile requires shareholder focus. As you have seen, Mittal's decision to bypass the board and appeal directly to shareholders proved crucial. So in a public company, the board's resistance can be overcome if enough shareholders believe in the deal's merits. The second is incremental concessions and strategic flexibility. Now, rather than offering the maximum value upfront, Mittal used a phased escalation strategy to control costs and test board resistance levels. The third is reputation and legitimacy building. Now, addressing concerns about governance and social license to operate was essential for shifting sentiment in politically sensitive environments. The last two things, I'm sorry, the last two things is things that I'm going to say from Arcelor's perspective. Uh, Now, defense tactics can backfire because Arcelor's use of Severstal as a white knight, coupled with aggressive defense tactics, was seen as shareholder unfriendly, which ultimately weakened uh, its position. And the last one, of course, is an understanding of the fact that negotiation is inevitable. So even in hostile deals, negotiation and settlement are often the final path, especially when economic logic and shareholder sentiment align. So that's the understanding that you had to have. And that's the end, or that's also the end of today's lecture. I have tried to be a little simple with my language because I understand a lot of you might be, I mean, listening to something in so much, complexity for the first time. So excuse me if I use any complicated terms, but I'll be happy to take questions if any. Now that we're done with the session. Okay, I don't see that there are any questions. There's nothing on the chat box as well. I hand it over to you, legal specs, for any concluding remarks that you might want to have.
Yes, sir. Thank you so much, everyone, for joining, and thank you, sir, for this session. And I am sharing a link to a Google form, which all of you need to fill out before you can leave. Sir will be available even the next week in case you want to go through the entire session once more and come up with doubts in the subsequent session. And sir has also provided his email and contact number quite a few times. You can also reach out to him like that, or you can reach out to one of us and we can forward your questions to sir and he can answer them whenever he's free. So thank you everyone. Thank you, sir. I hope you have a great weekend.
Thank you, everyone. Have a good weekend. Also, representative of Legal Space, I just had a quick question. The language of the sessions are seeming fine, right? Like I'm not getting too complicated.
Yes, sir. No, sir.
Spending a lot of time and really saying what I'm saying very wisely so that people understand it.
I understand, sir. It is actually pretty easy to understand. It's
Okay,
good, sir.
that's good. That's good then. Thank you.
Thank you, sir. The interns, please fill out the forms before you start leaving. Thank you.